What is S Corp bankruptcy? Have you ever wondered what happens when an S corporation faces financial trouble? S corporation bankruptcy is a process that allows these businesses to seek protection when they can no longer meet their financial obligations. An S corporation is a unique business structure that allows income, losses, deductions, and credits to pass through to shareholders for tax purposes. This means that the corporation itself does not pay federal income tax at the corporate level. Instead, shareholders report the corporation's financial results on their personal tax returns. When an S corporation runs into financial distress, it may file for bankruptcy under either Chapter 7 or Chapter 11 of the Bankruptcy Code. Chapter 7 is all about liquidation. In this scenario, the corporation's assets are sold off to pay creditors, and the business ceases operations. On the other hand, Chapter 11 allows for reorganization. This means the corporation can restructure its debts while potentially continuing operations and repaying creditors over time. One of the benefits of being an S corporation is that shareholders typically have limited personal liability for the corporation's debts. This means their personal assets are generally protected. However, there are exceptions. If shareholders have provided personal guarantees on business debts or engaged in improper conduct, they may be held personally liable for certain obligations. When an S corporation files for bankruptcy, an automatic stay is triggered. This stay halts creditor collection efforts, giving the corporation some breathing room to develop a repayment or liquidation plan under court supervision. Bankruptcy also brings significant tax implications. For instance, if debts are forgiven during bankruptcy, they may be treated as taxable income for shareholders. This can impact their personal tax returns. If the corporation is liquidated, shareholders might realize capital losses that could offset other capital gains. Choosing between Chapter 7 and Chapter 11 depends on the corporation's financial viability. If there is a realistic path to recovery, Chapter 11 may be the better choice. However, if the business has no chance of recovery, Chapter 7 liquidation is often the appropriate route. In essence, S corporation bankruptcy is a legal process for addressing insolvency through either liquidation or reorganization. It involves important considerations regarding shareholder liability, tax consequences, and the choice of bankruptcy chapter based on the business's prospects. Understanding these factors is essential for shareholders and business owners facing financial difficulties with an S corporation.